Good evening from New York. I'm Chris Hayes. It is not often the case these days, but today, the Supreme Court issued a long-anticipated, monumental ruling that actually bolsters America's democratic strength. Now, the case before the court today contained at its core an idea that was central to the Donald Trump scheme to overturn the 2020 elections. The question of whether state legislatures can do whatever they want in elections, up to and including simply appointing electors to their preferred candidate, even when the citizens of their state vote the other way. Trump's lawyers pushed the idea that Republican legislators in all kinds of states could simply ignore the will of the people in states that voted for Joe Biden and opt instead to send their own fake electors, Trump electors, to Congress. It was fake electors in 7 swing states, Arizona, Georgia, Michigan, Pennsylvania, New Mexico, and Nevada, that in coordination with the Trump campaign sought to overthrow the election results. Trump and his lawyer John Eastman, along with others, actively lobbied for and pushed this idea across multiple states, trying, in fact, to get state legislatures to abandon their core democratic duty and choose instead a path to essentially crown Trump king. Here's the former Speaker of the Arizona House, Republican conservative Rusty Bowers, describing a 2020 call he got from Trump coup lawyer John Eastman.
And what did Dr. Eastman want you to do?
That we would, in fact, take a vote to overthrow, or I shouldn't say overthrow, that we would decertify the electors, and that because we had plenary authority to do so. And I said, what would you have me do? And he said, just do it and let the court sort it out.
Plenary authority, absolute, total authority. The state legislators have total authority over who wins an election. We now have new reporting from the Washington Post that special counsel Jack Smith has taken a keen interest in the fake electors plot, focusing specifically on potential fraud. New York Times recently reported that one of the Trump campaign's key players in the scheme may actually be cooperating with federal prosecutors. And tomorrow, Republican Georgia Secretary of State Brad Raffensperger, who Trump infamously called and told to find roughly 11,000 votes to overturn the Georgia results, will meet with federal prosecutors for, as far as we know, the first time on the special counsel's team in Atlanta. We're going to have more on the special counsel's investigation and the rapid developments coming up. But again, at the core of Trump's attempted coup, and there's a bunch of things going on, but at its core, as articulated by John Eastman, as he told Rusty Bowers, is this bizarre, to my mind, facially ludicrous fringe idea that conservatives ran with after their scheme failed to return Trump to the White House. It's called the independent state legislature theory, although calling it a theory gives it a little too much credit. And it would give state legislatures plenarily, virtually unchecked power over federal elections. It was an idea infamously pushed by coup memo author John Eastman and his allies in Congress. Basically says state legislatures are the ultimate arbiters of how elections are run in a state, no matter what state law or state officials or, crucially, state courts say.
All we are demanding of Vice President Pence is this afternoon at 1 o'clock, he let the legislatures of the state look into this so we get to the bottom of it and the American people know whether we have control of the direction of our government or not. This is bigger than President Trump. It is the very essence of our Republican form of government, and it has to be done. And anybody that is not willing to stand up to do it does not deserve to be in the office. It is that simple.
That was the speech at the Ellipse right before an angry mob went to the Capitol and bashed a bunch of cops' brains in. The insurrection on January 6th failed in its goal to subvert democracy. It failed to keep Donald Trump in office for a second term. But in many ways, the spirit of the coup, of Donald Trump's multi-pronged plan to overturn the election results, continued and continues. I mean, we've seen in state after state, like Arizona, Georgia, and Texas, Republicans stripping power from state elections officials, and candidates vowing to abolish bipartisan election commissions in states like Wisconsin. So this time, it wasn't a violent mob, but politicians, locally elected officials at the state level, trying to carry out a version of Eastman's vision, right? To take power back from any official that has it delegated and give it all to the state legislatures so that they can run elections entirely. Not coincidentally, those are also the places where Republicans have a lot of control. And they've been doing it right in front of all of us. I mean, we were covering it back in May of 2021. In Arizona, Republican state legislators stripped Secretary of State Katie Hobbs, a Democrat, of her ability to defend election lawsuits. And it gave the power to who? Well, exclusively to the Attorney General, a Republican. We are watching essentially a slow motion insurrection being carried out by Republicans in suits and ties in states all across the country. They are putting the pieces in place to do in the next elections what the mob failed to do on January 6th. And that slow motion insurrection, this idea from the right wing that the power of self-governance does not sit in the hands of the people, the idea that the power and oversight of elections belongs to basically Republican self-gerrymandered majorities in the state level, that idea, that core idea, is the subject of today's monumental Supreme Court ruling. The case is out of the state of North Carolina. It's called Moore v. Harper. And in it, North Carolina Republicans argued that this independent state legislature theory gave them virtually unchecked power over elections.
The lawmakers' argument hinges on a political concept called the independent state legislature theory, based on the Constitution's election clause saying the time, place, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. So if the court lands on the side of North Carolina House Speaker Tim Moore and his Republican colleagues, Fredrickson explains it could mean state legislatures can act independently and governors and state courts would have no ability to check laws related to federal election.
Well, today in a 6-3 ruling, the Supreme Court rejected that extreme and dangerous legal theory, not to say one completely unfounded in the text of the Constitution. The case centers around an extremely aggressive partisan North Carolina congressional map drawn by Republicans in the state legislature, very gerrymandered, using 2020 census data. And it's a map that would give Republicans up to 10 seats in the House. In early 2022, the North Carolina Supreme Court threw out that gerrymandered map and rejected Republicans' arguments that state courts had no role to play in drawing congressional maps. And then conservatives tried to go over the state court's head, challenged the ruling on the cart, and went to the Supreme Court to argue that the Constitution gives them and only them, us in the state legislature, the only and total power over how we draw congressional maps. State courts don't matter. Well, today, the conservative Supreme Court that Donald Trump is responsible for shaping plainly rejected this radical and, dare I say it, kooky notion. Chief Justice John Roberts authored the 6-3 opinion with both Trump-appointed Justices Brett Kavanaugh and Amy Coney Barrett siding with the liberals. Justices Clarence Thomas, Samuel Alito, and Neil Gorsuch dissented. In his opinion for the majority, Chief Justice wrote that, quote, legislatures, the framers recognized, are the mere creatures of the state constitutions and cannot be greater than their creators. Meaning, the state government as a whole functions to oversee elections. If there's a state constitution that's interpreted by state courts, they get a say. State legislatures aren't some like special magical power that overrules everything in a state. That's ludicrous. This is the second pro-democracy ruling from this very right-wing court this term alone. Remember, a few weeks ago, they also upheld, crucially, Section 2 of the Voting Rights Act and struck down a flagrantly biased Alabama congressional map. And I can't read the minds of the justices, particularly Roberts and Kavanaugh, who are the majority in both opinions, but I have to think the sustained focus amongst the press and civil society and politicians on the very real, indeed existential threats to the American experiment as posed by John Eastman, Donald Trump, and his movement. The focus on that has shaped the court's thinking, and thank goodness for that.